All right, good morning, Mr. Narcisse. So you're charged with unlawful carrying of a weapon. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On April 20th, 2025, in Harrison County, Texas, a law enforcement officer was dispatched to a disturbance of a weapon call at a hotel. The hotel staff said that an unidentified third party alerted them that the defendant had a weapon. The defendant was detained, and a witness told the law enforcement officers that the defendant had a backpack behind a bush prior to the law enforcement officers' arrival. The backpack was recovered, and a handgun was found in the backpack. The defendant is currently 19 years old.
You like Skip. How do they know the backpack was his? What was he doing wrong?
There was a witness, Your Honor, that stated that they saw the defendant hide the backpack behind a bush, and the hotel staff was able to identify the defendant as the individual they were told had a gun. And that's when the officer.
Was he just standing while black or something? What's he doing wrong?
They were just alerted.
No. I'm going to find no probable cause in your case, Mr. Narcisse. Be careful, man. So many out there out to get you, put you down. You know, you're 19. Do something with your life. Don't become a statistic. Hang tight for me. I'm sorry. I'm just getting wind of this now. I didn't realize this. He just picked this up.
My client or the person?
Yeah, him. Picked up an interference 2 days ago.
That's what I'd like to revisit.
Yeah, of course. So you were on felony probation for a very serious case, evading arrest in a motor vehicle, which carries up to 10 years in prison. Now you've picked up a new case. Greg, I got to tell you that I don't know how much you know, but I have quite a bit of history with Mr. Zenon here. In fact, within the last 2.5 years, 1, 2, 3, 4, 5, 6, 7, 8, 9. Now he's on his 10th case, specifically an unlawful carrying of a weapon, another unlawful carrying of a weapon, another unlawful carrying of a weapon, another unlawful carrying of a weapon, a felony possession of marijuana, felony assault of a pregnant person. And I guess all that worked into a deal where he got on probation for an evading. And now we have.
Right, but all those cases were dismissed, correct, Your Honor? Okay.
Pursuant to the, I guess.
I understand.
That we literally had one after the other, like a rung on a step ladder. One after the other. So let's do probable cause.
Thank you, Your Honor.
You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you. I just wanted to give you a heads up of how much history we have with Mr. Zenon, because it's a lot.
I appreciate that, Your Honor.
Sure.
But be that as it may.
I'm not going to hold, I've never will hold anything against him. So let's go.
On December 3rd of 2024, officers were dispatched to the HEB located at 4955 State Highway 6 regarding a disturbance in progress. Officers received 4 calls, all from witnesses who stated the defendant was arguing with and assaulting a female. While en route to the location, officers observed the couple at the intersection about 0.1 miles away from the HEB where the original call was
Observed what?
located. They saw the couple at the intersection.
Okay, they saw. Okay.
Yes, Judge. The defendant was uncooperative with officers. The defendant advised he and the complainant were involved in a verbal altercation and stated he threatened her, saying he would slap her. When officers advised the defendant that he was in custody for an outstanding warrant, he got upset and began to yell. Officers located a clear plastic bag containing 3.6 grams of marijuana. The defendant refused to comply with officers' commands to sit down and would not place his legs and feet inside the vehicle. The defendant pushed back against the officer's hand with his chest when he attempted to help him into the vehicle, pushed his legs straight and applied force toward officer's hand in an attempt to stop him from placing his legs inside the vehicle, and then used the bottom of his foot against the bottom of the door frame to further resist. The defendant refused to speak with officers and would not cooperate with the investigation. All witnesses on scene heard the defendant threaten to hit CW, And another witness stated she observed the defendant push the complainant in the chest and face with 2 open hands. He does have an active felony warrant from the Fort Bend County Sheriff's Office for aggravated assault with a deadly weapon
But he has an open ag assault somewhere else too?
in Fort Bend County, Judge.
My understanding is it's
And
an
it was
older
open
case.
warrant at that time?
Yes, Judge.
May I respond to all this, Your Honor?
Sure, please.
Where's the interference? Okay.
Well, they're putting him in a car and he's like going
Judge, how-
blank.
It's not interference with public duties. If they're sitting there saying they have a marijuana charge they could have done, is it a resisting? Maybe,
So,
but it's not an interference with the public duties. They said he didn't talk. He doesn't have to talk to them. Like, and they're
I understand
and
that.
they're a 0.1 mile away from the location
So-
for what?
Well, okay, I get that, but so we have what we have. We've got a disturbance at HEB. Cops go there.
Okay.
They start to talk to him, and I guess at that point says, "Hey, man, I'm going to slap her." So at that point, I mean, that's what we have,
Okay.
right, Mr. Zenon? There's always 2 sides to the story. I get it. This is just probable cause. It doesn't mean that you're guilty of this offense. It's just probable cause. That, in and of itself, is it enough to continue an investigation? And it is, because it's a potential terroristic threat, right? So they have enough to go forward to investigate. They start investigating, and then they find that you have a felony open warrant. And then they find there was something else was there another warrant that you said?
No, it's the aggravated assault, but Judge, I also would like to point out that
But they end up putting him in the car. And at that point, he basically just goes plank like this for them being unable to effectuate an arrest.
And Judge,
You don't think that's an interference?
I don't. I mean, I think the intent of the law within itself is that if you're interfering with their investigation for something else. He did not interfere with anything.
Hold on, let's read the code. Let's read it, because, I mean, there's no better way. Let's read it.
Hold on.
I'll give you, all right, hold on. Let's pull up the code.
Intake could have taken some other things, but
Well, certainly, they could have
Okay.
taken a whole myriad of, I mean, you're lucky they didn't charge you with assault of a peace officer. There's a whole host of other charges that they could have put on, you know?
but they didn't
Hit.
they took the one that I do not believe applies here.
Let's read the code.
Okay.
Let's see what the code says, because, you know, there's multiple ways that a charge can, you know, that you can charge someone with facts, right? There's multiple ways that can, you're right, it could have been like a resisting, you know, but. Okay, you ready? A person commits an offense if the person with criminal negligence interrupts, disrupts, impedes, or otherwise interferes with, number 1, a peace officer while the peace officer is performing a duty or exercising authority imposed or granted by law. 2, a person who is employed to provide emergency medical services, a firefighter. Number 3, for an animal under supervision. Now, so I guess it's a person, it interrupts, disrupts, impedes, or otherwise interferes with, number 1, a peace officer while the peace officer is performing a duty or exercising authority imposed or granted by law.
That is the vaguest thing I've ever heard in my life. I mean, come on.
It is. I agree
Okay,
with
so
you.
the cop can claim anything is interfering with public duties. I mean, constitutionally, that is the vaguest thing I've ever heard of.
Judge, that's the statute, that's the penal code.
You'll find no argument with me, right? It is pretty vague.
Yeah.
It is.
He's got bigger issues. I mean, they should have taken the other charges, my whole point. I mean,
But he's disrupting the officer while he's trying to discharge a duty, right? The officer's trying to arrest him and put him in the car, and he's not letting him do it.
I mean, that's assuming they even had the right to do that. I mean, he's 0.1
It's an open
miles away.
felony warrant.
They didn't even know about the warrant. They didn't know about the warrant till after. So, I mean, that comes after all of this.
They're saying, go ahead. I didn't even give you a chance to talk.
No, you're okay,
Please.
Judge. They were investigating the assault, Judge, is what the threat that he admitted to making. So it was an active investigation, and then when they were detaining him, he was resisting arrest, is what it seems like. And that's why it was charged with interference with public servant.
And there were also 4 911 calls that were made about this couple arguing. I mean, that's what they were investigating.
And the witnesses all
They
described
put him,
the
I guess,
defendant.
did they put him under arrest at the time when he said that he was making that threat?
And with being
I mean,
point
did they
one
have the authority to arrest at that time? Right?
So I think it was during their investigation, the defendant admitted to threatening, that he would slap the Miss Clark.
And it's at that point they start to put him under arrest?
At that point, they ran him through the NCIC and they found that there was an active warrant, and then they informed him that he was in custody.
Okay, then that's a resisting from what they're using to say he's pushing back or
But
pushing.
remember,
That's
I
a
mean,
resist.
it-
That's not
it
interference
could
with
be-
public duties.
But it could be that a set of facts can be multiple charges, right? So it could be resisting, but it could also theoretically be interfering with what he's trying to effectuate with, which is an arrest. It's a duty that he's performing. He's performing the duty of an arrest.
But again, it's vague. If the officer didn't put in the report, he's not saying in the dim summary, you are under arrest.
We don't.
Well, I mean, it's,
Okay, well, I mean, but so
I mean,
this
we
is,
don't know. I mean,
okay, I'm just saying.
if he says he's under arrest, but I mean, damn, it's all but clear.
I mean, this is,
we also
And
don't
he's-
have the offense report
We
yet,
don't
I
have
don't
Judge.
care. I
He
mean,
was in the
but I think that
process.
there's enough, he's under, he places him in custody, right? He's going to arrest him, starts putting him in the car, and dude goes plank.
I see, I know, but I don't have the video.
I
I've
mean, I
shared the
think that-
videos with.
Remember-
You're right, I haven't had a chance.
Guys, this is a very low burden. This is probable cause. This is not beyond a reasonable doubt, you know? Beyond a reasonable doubt is a different standard. This is just to see if there's enough to go forward. And according to this, you are disrupting, allegedly, you're impeding, and you're otherwise interfering with him trying to arrest you and putting you in the car. A person can interfere with duties in multiple ways. It's not just one way. Like you go over there and someone else tries to stop an arrest from happening. I don't know. I think that there's enough.
Whisper to me because I want to know what you're about to say.
And if you want time, you guys can go back and talk.
Okay, well, I gotta say,
Required 3 times to search me.
can I have a moment to look at the video here? He's telling me a whole separate fact pattern.
But I need to give them time to be able to look at it too. I mean, it's noon. Why don't we do this? Why don't we roll it to Monday and we can, I'll find it now. We can reapproach Monday morning or tomorrow even. And if you find,
Because I
if
want
you
to
find a
walk out.
completely set of different facts than to what they're saying on video, I'm all ears. I'm always all ears. I'm always willing to rehear probable cause at any time. I mean, it's not the be all end all. But for now, what they're telling me, if it in fact is the case, there's enough for probable cause to go forward. Is there enough beyond a reasonable doubt? I don't know. But be that as it may, okay, it looks like they didn't give him a PR bond on this.
Okay, so well, then we
The
address it.
bond right now is set at 2,500.
Okay,
Your bond upstairs is set at 5,000. Tell me about that Fort Bend case. Is it old? Is it new?
Let me check, Judge.
I think it's 2023.
Is it? I don't know. I mean, because it looks like you got on probation in October of this year. When you're on probation, dude, on felony probation, you have a freaking halo over your head. You got to be as good as you can. You're facing a lot of time in prison. Have you been to prison before?
Sir. No, sir.
It's not a fun place, and I don't know what we need to do to get your attention, man. In life, if you're with a person that brings the worst out in you, then don't be with that person. There's a gajillion and one fish in the sea, but how can a person get you so wrapped around your finger to make you, Just go. It's like a cancer. When you have cancer, if you don't cut it out, it kills you. This is killing you.
I can contact Fort Bend judge and get more information.
Well, it doesn't matter. It's neither here nor there. I'll do whatever you want to do. You want to set
I mean-
tomorrow, Monday, what in?
I'll watch it today and come back tomorrow if you want.
Yeah, I mean, if you want. Surely. Do you have it?
We have the camera, the body camera.
I just shared.
Okay,
it.
so
They
Let's-
shared it. They just shared it with me.
Yes.
let's roll it to tomorrow. You guys take a look at the video as well. Be prepared, and then we can reconvene tomorrow. For purposes of now, I'll find probable cause, and then we can regroup again tomorrow.
Okay, thank you.
Okay. All right, Mrs. Zenon.
Hey, come on.
See you tomorrow.
See you tomorrow. Probably gonna agree to disagree here. But I would like for you to watch like the 2 minutes of the video that I think.
So Judge, I also, because you had this question yesterday, I called Fort Bend and they confirmed it. The Fort Bend County aggravated assault with a deadly weapon, it's just sealed, and that's why I didn't pop up.
It's
for
just
it.
what?
It's sealed at the moment.
Sealed. Is it a new case? Is it an
It
old
was
case?
just filed in November, Judge,
Wow.
but the offense date was in March.
Okay, so that's what I'm asking. It was the offense date was March of 24.
Yes.
So it was allegedly committed prior to, now nevertheless, it's still a
It
warrant,
was,
but how on earth has it never been?
it's because, so they'll unseal it whenever an arrest happens, Judge. The case was filed. He had 2 other charges in this county, even that he caught even after that one.
I'm so confused. You know that there's a, Fort Bend knows that there's a felony warrant, a dangerous felony warrant, and they failed to execute that warrant over and over. He's been on probation. He's been
Yes, but
meeting with his,
Reading in here that he's got on 2 years probation for, and then had also a UCW here that he caught after that. And another assault of a pregnant person that he caught here after that, and then another UCW that he caught here after that. So he had just a string of cases, and I mean, the list goes on. But there was just a string of cases that he caught even after that, so I guess they just never, I don't know.
I will tell you the shenanigans from my experience that Fort Bend does. So if they think they're going to TDC, I have seen them let them go to TDC, wait till they even make parole or discharge or finish that sentence, right? And then they're out and they go, oh, now we're going to file you. And then parole goes, oh, now we're going to revoke your parole. Those are the shenanigans that I've seen.
Judge, I
And this
can't-
has been going on for years out there, like prior administration continuing.
but I mean, I guess ultimately at the end of the day, even if that happens, like, let's just say the parole board's gonna look and see that was like extremely old, right? I would have the first time he failed.
I'm not gonna read it. It doesn't matter.
Okay.
Is in,
I mean, it doesn't matter. It's on video. It
So I'll
doesn't
make a
matter.
note.
Okay.
Insurance required, but you know,
correct.
if he
Right.
pays.
On video, guys. Like I watched it. I'm not crazy. Like this, it's on video.
Sorry to keep you
Let's
waiting.
talk to Judge about it.
Okay. You're still upset?
Yes, I watched the video and I'm even more upset,
So-
Judge.
So Judge, we just want to address some of the questions that defense and you had yesterday. Defense was saying that he felt that interference statute was overbroad. We found case law saying that it's, or vague, that it's unconstitutionally vague. We found case law saying that it's not unconstitutionally vague. It's from DeContal versus State. I've tendered it to defense. Can I
Sure,
approach
of
Judge?
course. I gotta imagine that if it was unconstitutionally vague, someone would have challenged it and it would have,
Well, maybe they haven't had my case yet.
Okay.
and, I'm happy for you to make new law, always. Why are you saying that there's no PC in this case?
Is there a PC for something else? Yes. Is there for the interference with public duties? No. I mean, because it's on video, it didn't happen, Judge. Like, so they get calls for an assault, a disturbance, whatever.
You're telling me the fact that they're saying he goes plank in the car while
He doesn't.
being arrested
He
doesn't
does
happen?
not go plank. It's on video, Judge.
Would they say he uses his I guess he uses
He's in
his,
handcuffs.
The officer has to place his hand on the chest of the defendant to get the defendant to sit back in the car. He also has to grab his legs and push them back into the car. We also watched the video.
We watched the video and we have a timestamp, Judge.
could it be that okay, so I know that a lot of times when they're putting a defendant into the car, they need help, right? They're unable to do it by themselves, or is he actively resisting getting into the car?
He tried exiting the vehicle, Judge. And
No,
that's
he-
why they had to push him back into it.
He leans forward, he's yelling at his mom, record, call. The third time they have taken him out, this is 3 times. They put him in the car and they take him out so they can search him. The cop is sitting there going, oh, well, search him again. We can search him 20 times. If you feel you need to search him 20 times, search him 20 times for your safety. The cop doesn't even know what he's charging him with. DA hasn't been caught. The cop's sitting there go, we're getting you for resisting transport. Resisting transport. That is what the cop thinks he's taking of it. DA, Officer Singh, it's a 27-minute video. Okay? At no point is the DA's office called to this point. Okay? That happens after. Fine. For an assault, they can argue. I can argue case law. Ford v. State, specific articulable facts of crime may have occurred. Fine. They are there on an assault. Okay? They didn't take an assault. So then they detain him, right? They find that he has the warrant. So, okay, you're taking him in on the warrant. Fine.
Judge, it's
It's
common for officers to conduct an investigation before they call intake. That's not an abnormal
Yeah,
thing.
I mean, that's neither here nor there, but the question is he impeding the arrest or the function of arrest? Because I guess that you guys are basing the interference on the fact that he's not allowing him that, what's his name again?
Xenon, Your Honor.
Mr. Xenon is not allowing the officer to arrest him by putting him in the car.
Respectfully, Judge, the officer doesn't even have to be arresting him. They just have to be looking into any legitimate matter. And then he's interfering with that. And I will say, if he'd already been in the car 3 times, like defense pointed out, I would think he wouldn't need help getting in. So to us, it appears as though he's trying to push out. The officer has to put his hand on his chest to push him back into the car and then take his legs and place them into the car.
He was cooperative the whole time. He's on his mom. If anyone's aggressive, it's the cop from the beginning.
Judge, the
And
cop-
I ask at the court's discretion, watch the video. You only need to watch like 2 minutes, the 13 to 15 minute mark, Your Honor. I mean, that's all you really need to watch on this.
Judge,
Watch it now.
We can watch the video, Judge.
Cue it up. Let's watch. Can you put it on the screen somehow? So we can all watch?
we can just go to the back and watch it. Do you want to hook it up? I don't, because he has issues hooking his computer up to the technology. The whole video, or did you?
No,
want to-
just the relevant portion. I don't need to see the whole thing. No, just that part that's relevant. You know, I guess if you wouldn't just put it right there and just turn it around.
Yeah, just put it
Just
up
right
there.
on the table. Yeah, right there. And set it.
I'm just turning the volume up, Judge, as well.
He talking about don't let him pull up. They talking about I got a warrant out for Fort Bend County for assault. Look, he pushing me. Mama, record him. Mama, look, record him.
Now you're under arrest.
I'm under arrest.
Yep,
for
you
what?
got a new charge, Bubba. Resisting transport.
Resisting? I wasn't resisting.
You just resisted transport. Yep. You're going to
What the
jail.
hell is that?
Now you got a new charge. Yep.
Come on.
Thank you,
These
Judge.
officers are working intake, Judge.
Really? That's it?
That's it, Your Honor.
That's the relevant portion that defense is.
Oh, come on.
The officer is investigating a legitimate.
I know, but no. All right, I'm
Do
with
you
you.
see why I'm so upset, Your Honor?
All right.
Okay. Thank you.
You can refile this as resisting.
Yeah, look, yeah, I mean, you're not gonna hurt our feelings. You need to do what you need to do. Perhaps it was the wrong one, but yeah. Was it resisting?
Nope.
My name is Bennett and I ain't in it. But no PC.
Thank you, Your Honor.
Your attitude toward me right now, Mr. Alexander, it really, really sucks. You have an air of arrogance. Good morning, Mr. Alexander. So you're charged with terroristic threat. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you.
2024, officers were dispatched to 11910 Chetman Drive in Harris County, Texas. The complainant, the mother of the defendant, told the officers that her 11-year-old son, the second complainant, was riding his bike down the street when he passed the defendant. Complainant 2 and the defendant know each other. When they passed, the defendant began insulting the son, and the defendant pulled what appeared to be a tan handgun from his waistband and pointed at the second complainant while making remarks about shooting him. After the second complainant told his family about what happened, they went to look for the defendant and confronted him. The defendant reached into his waistband again, but the complainant's family was able to wrestle the gun away, which turned out to be a BB gun. The officers noted that the BB gun appeared to be very similar to a real gun in appearance.
Mr. Alexander, are you here with anyone today?
Sure.
Who are you here with?
My mom.
Go grab her, please. Go grab your mom.
Your mom?
Yes.
Come on up.
Come on up, Mom.
Good morning.
Hi. Thank you so much for coming.
No problem.
Did you hear everything that happened?
Some of it, I couldn't hear all of it.
Let's hear it again. Okay, do you mind,
Yes,
please?
Your Honor.
Thanks.
On September 23rd, officers were dispatched to 11910 Chetman Drive in Harris County, Texas. The complainant, the mother of the 13-year-old boy, told the officers that her son was riding down the street riding his bike when the son passed the defendant. The complainant and the defendant know each other, and when they passed, the defendant began insulting the son, and the defendant pulled what appeared to be a tan handgun from his waistband and pointed it at the complainant while making remarks about shooting him. After the complainant told his family about what happened, they went to look for the defendant and confronted him. The defendant reached into the waistband again, but the complainant's family was able to wrestle away the gun, which turned out to be a BB gun. The officers noted the BB gun appeared to be very similar to a real gun in appearance.
Lucky he's not charged with aggravated assault. You know, they could charge you with a very serious offense where you're looking at serious time in prison. You're lucky they didn't, Mr. Alexander. How old are you, sir? You're 18. What do you do with yourself these days? Spit the gum out, man.
You chewing gum?
Your attitude toward me right now, Mr. Alexander, it really, really sucks. You have an air of arrogance on you. Either that or has he been with you all morning?
I'm sorry?
Has he been with you all morning?
Yes, yes.
If I drug test you right now, what's going to show up, Mr. Alexander? What's going to show up? I'm sending him for a drug and alcohol test right now. I'd like to know what, if anything, is in his system. We have to. I don't even know what to say, but all I know.
I mean, you brought me up here, so do I have permission to speak?
Absolutely.
Okay, so respectfully, I would submit that these are the alleged charges. There is extenuating circumstances, and the report from the complainant is actually not accurate. That family has actually made verbal and written threats to my son, and we have proof of that. So while I understand that these sound quite egregious, it is not the whole story.
I understand. And I know that there's always two sides to a story. I get it. And you will have the opportunity. But within the first 5 minutes that I've met him, his behavior towards me, his demeanor, the way he looks, just.
That's anxiety. He's standing in the courtroom. He's standing in the courtroom for the first time. And he doesn't have his attorney. He doesn't have an attorney yet. And this is a process that's foreign to him. So what I would, implore from you is don't take his demeanor as disrespect. He is anxious. He's been anxious all morning. He has been with me all morning, and he doesn't really know what to say. So I understand that you're getting a first impression from him, but he is still a very young adult, and this is his first experience in a courtroom.
Right. I agree with you. Mr. Alexander, what you need to understand is that you're 18. You've got this bag of money on your neck, and this life is but a very, very short. Look at me. Look at me. This life is a very short one, and it can be a very happy life, or it can be a rotten, miserable existence of a life. What you do now will dictate the next 40 to 50 years of your life. You work hard now at 18 to 20 to 30 to maybe 40, so that you're not working like a dog when you're 70 to 80, and you can actually have a life and retire. This, by picking up criminal cases at 18, you're moving backwards. How far did you even make it in high school?
He's uncomfortable talking to me, asking me to answer.
I want you to answer. I want to get to know you, Mr. Alexander. I want to know what's your, sorry?
Said 11th grade, Your
He said
Honor.
11th grade.
You need an education, Mr. Alexander. If you're going to do anything in this life, you need an education.
I got my education.
I want to do everything I can to help you out. Okay? I really do. If he's smoking weed, it stops today. Okay? I'm going to drug test him right now because I want to know what, if anything, is in his system. If he tests positive, then I'm going to test him again in 40 days, give or take. The marijuana stops now. And I want him to get back in school. He either needs to be in school full-time or get a full-time job so that he's not running in the streets. Mr. Alexander, I am also making it a condition of your bond that you're not allowed to have any kind of weapons whatsoever for any reason. I can give you a lawyer to try to help you out as much as I can, and I will waive all your fees so you won't be responsible for any cost for anything.
Thank you.
All I want is him to be as productive and as good of a person as he can be. And starting out with criminal cases at 18 and to where he can't even talk to me, we need to change that.
If I just make a comment about the bond conditions.
Sure, of course.
I called the complainant's mother in this case a few days ago and kind of spoke to her about what happened. And I learned that there is a history between this family and the defendant. Back in the summer, this defendant stole a gun out of the complainant's house. He asked to enter the house under the guise that his mother had kicked him out, went into one of the complainant's uncle's bedrooms and stole a gun. He FaceTimed the complainant's uncle a few days later, flashing the gun, telling them that he was going to come hit up the house while flashing the gun at him. They used to walk to the same bus stop. They used to come out of the same bus stop, the complainant and this defendant. The complainant is terrified of the defendant. We've asked for no contact. We've also asked for GPS monitoring because of that. They don't attend the same school, but they were I guess they were stopping at the same bus stop. Now the complainant asks that his uncle walks into the school bus every day because he is so scared of the defendant. And as I think is mentioned in the PC statement, the complainant in this case is 13 years old.
Was there a police report filed for that incident?
There was. I have the incident number.
For that one you're referring to about the gun?
Yes, where the gun was stolen.
What happened? They didn't follow it up. They didn't call the police. They didn't, theft of a firearm is a very serious felony.
According to the complainant's mother, they filed a report. She provided me with an incident number.
How long ago was this?
This was she said July. It was in July. I can attempt to follow up with the responding agency. I'm not sure if it was the sheriff's office or not, but I mean, either way, there is like a history between these two families. And the complainant and his mother are both in fear of the defendant.
So, Mr. Alexander.
I would again submit that this family lives around the corner from us. We have never been approached. He lives at home with me. In July, we actually were in Panama for his 18th birthday. We weren't even home. There was never a time he was kicked out of my house.
Were you out in Panama the entire month?
We were out in Panama from July 10th until the beginning of August, yes.
Well,
So,
that's not the entire month.
well, most of the month, excuse me. And in addition to that, there's no one has come to investigate anything at my house.
Okay, so Mr. Alexander, I'm issuing a protective order over this child, this other kid. You're not allowed to have contact with this person or go within 200 feet of where they live or where they work. Do you understand, sir? You're not allowed to be in possession of weapons. You're not allowed to have any kind of threatening or harassing behavior with this child. If they call back and they say that you have harassed them, then I will revoke the bond and I'm going to put you in jail. And I'm going to tell you now, I will not give you any more PR bonds. So all I'm asking you to do is stay away. No one is finding you guilty now. We're just asking that you guys separate and don't have any contact. That's it. I am going to put an ankle monitor so I know that you're not going anywhere near their house. But like I said, I'll cover the cost of anything, so it won't cost you guys anything. You must charge this thing on a daily basis, Mr. Alexander. If you don't charge it, the battery goes dead, then we will file a motion to revoke. Not a motion to revoke, but I'll revoke the bond. So as it stands now, what we'll do is I will send you now for a drug test. We're going to have you come back. I want to know what, if anything, is in it. And then I will provide you between now and then a lawyer, and we'll go from there. Do you have any other questions?
That family is in possession of my bicycle, not his, it's mine. They actually stole that from him. You know, I would like my bike back.
There's proper channels to do it. I don't know how, but as it stands now, he can't go over there, can't have any contact with them
That's fine.
whatsoever. You know, and I would venture to guess that if you go over there as well, it's probably gonna be even more bad blood. So
No, I don't have any.
perhaps you can find someone else, like another intermediary, that can go over there and try to get a bike back. But at this point, just don't have any contact with them. And when you come back, then we'll have you speak to someone. Okay? All right. I'm gonna have you sign a go ahead.
One of them today.
Correct. Yes. Mr. Alexander, I want you to either get a job or get into school full time. But when you have too much time on your hands, you become self-destructive. Your brain craves activity. It needs activity. And when you don't challenge yourself with either school or a job or anything, then bad things are they're just gonna come and happen. You have to occupy your life. You have to do something. Where we're headed now, you're going the opposite way of how you should be doing things. This is not a good way to start at 18. All right, please. Let me express my extreme disappointment with you, Mr. Poole. You are on bond for an evading arrest, a criminal mischief. You've picked up an aggravated assault of a family member and now a terroristic threat. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney. Shh. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, Judge. The defendant is the complainant's ex-boyfriend. During a walk-in report, the complainant told the officers that her and the defendant had an on and off dating relationship since the 8th grade, but they broke up in June 2024. In September, the defendant told the complainant, "Stop talking all that mess before I come to your house and fucking shoot you." The complainant told the officers that right after the incident, the defendant sent her photos of a gun in his lap. The complainant stated the defendant also told one of the complainant's friends that he was going to shoot the complainant.
So tell me about the ag assault. What happened there?
Your Honor, in the ag assault, one moment.
In the criminal mischief, is it with the same complaining witness as well?
The criminal mischief's from a prior event where we had experimented trying a drug and kind of got crazy and broke stuff with it.
Yes, Your Honor. And then for the aggravated
Completely
assault,
unrelated.
it says the complainant and her friends went to a party, and at the party, they saw the defendant trying to get in, but was ultimately turned away because too many people were there already. While walking, the complainant ignored the defendant, and the defendant stated, "Are you going to apologize?" And the complainant kept walking. The defendant began cussing at the complainant and said, "I got it on me." And the defendant said the complainant said at that time, the defendant got a pistol from his ankle and pointed it at her. And then witnesses corroborated the complainant's statement. And Your Honor, there's also a pending terroristic threat out of Galveston as well for the same complaining witness. Yes.
Did you know about this?
I did not know about that.
Do you have an open case in Galveston as well? I think, Mr. Poole, that you are a complete and utter danger to our society. And I'm going to do everything in my power to protect Harris County from anyone that does any kind of damage whatsoever. I am now revoking your bonds on both of your other cases. Goes with you. I'm sorry. As much as I love you, it's unacceptable the way things have been going. And I think that you don't get the message. And now I hope you do. But I am now going to give you home confinement. You're not allowed out if you bond out of jail. I'm going to make your bond sky high. I think that you're a complete and utter danger to everyone. You flaunt our bond conditions. And it truly sad, Mr. Poole, because you have but one life. And when you have a gun and when you start using that, God forbid that you do some irreparable damage, that you dig yourself into a hole where you're looking at 50 to 60 years in prison, perhaps life. 99% of people that are in jail are there because they have no self-control. They either use something, they are on something, and they get upset. They wig out without thinking, if I say this, what's going to happen? If I do this, what's going to happen? It's unacceptable. And now I will do everything, like I said, in my power to protect Harris County. So if you do get out, you must remain home confinement. You're not allowed out. No weapons, no contact with any of the complaining witnesses whatsoever, no dope, no alcohol. Anything else? I mean, what does he do?
He's a student, Judge. He's a high school student. So
I don't know what to tell you, man. I mean, he scares me.
understood. And Chip and I are going to put some things together. I think that there's a different scenario really going on than what this reflects in the probable cause statements. And we're going to bring that to the prosecutors.
If you have something that shows me different to what they have, I'm all ears.
Understood.
And
with your permission, Judge, if we'll get some time to put that stuff together, we can perhaps readdress the bond.
Yeah, absolutely. And I never want to see a kid lose out on school, because to me, it's the most important thing in life,
Understood. If we do home confinement, can there be an exception to that when he's at school and he just has to report immediately back to his home?
Is he like in high school?
He's a high school student.
In high school.
I mean,
Yeah, Judge, he's actually currently, because of this situation, doing online school, so he'll be able to do it from home.
Oh, okay, good.
So disregard.
Good. There we go. Are you mom and dad? Come on up. Come up.
Come over close.
Thank you so much for coming. Shh. It's out of control. I don't know what else to do. But it seems that when he's out in public and he's out, partying, as they say, there's a wake of trouble. Did you guys know that he has a case in Galveston as well?
No, Your Honor, this is the first time I've heard of that.
Is it currently open?
It's currently open, Your Honor.
Something that the lawyers are also unaware of as well,
We think it's all one event that happened over a few hours. We don't know.
But it's not though. It's not. He's, 12 in December of 23, we have a criminal mischief and evading arrest. Now, a couple months later, we've got Galveston. It's not. And I think that we need to really give him a wake-up call before he really does irreparable damage,
If I could just clarify, the two events here in Harris and the one event in Galveston, we think that was all in the one series of events that happened between football games and a party on a hotel.
We need to figure out what's going on, to figure out why it's continuing to happen. And I want what's best for you, son. I really do. And I will help you in any way that I can. I have to put him in custody today because I have to show him that it's unacceptable what he's doing and picking up these tuna cases, especially the fact that he's picked up an aggravated assault. That's, you've got a great lawyer. We'll be here to figure it out with you.
And Judge, he's already addressed the bond on the felony case as well. So he's gone in and addressed everything with the felony. We're just
Bond, huh?
understood.
So I'm making your bonds 30,000 each. I don't know if they're going to bond you out, but if you do get out, you better be on your best behavior, and you are not to go anywhere. What I'd like to do is, I'm going to take him in now. I'd like to do an evaluation. It's called a TRAS to see what the best way of going forward. We have clinicians that can sit there and evaluate him, talk to him, figure out what's going on, and perhaps boot camp is the right way. Perhaps, we have these other things that we have at our disposal to see how we go forward. Because I just don't know. I don't know what's going on in his life. I don't know what he's doing, what he's taking,
We did already as part of the PTI, and they do want to increase him to what?
Say it again.
They want to increase his level of supervision to YMAX.
Who say that? Felony court?
No, misdemeanor, but this is a part of the PTI. He's already completed the TRS this year, so because of the new law violations and how things they kind of are, they want him to do YMAX.
Did you hear that?
I did. Judge, again, I think that these probable cause statements are giving a skewed picture of what's
So
really
that's
going
right. Let's not put the cart ahead of the horse. We'll give you time. And then if you see something different, just come back and let me know. Okay. Do you have any questions?
No.
If you need anything, always come back. We're here. We'll help you out in any way that we can. And sometimes some kids are harder to reach, but we'll do everything on our power to reach them one way or the other. So we got you. Okay. We'll take care of you one way or the other. Okay. All right. He goes with you. Oh yeah. I'm going to do a mow up. So hold on, Stephen, hold on. Mr. Poole, I'm entering in what's called the magistrate's order for emergency protection that identifies SM as a protected individual. You're not to commit family violence or an assault against this person, commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is the stalking statute. You cannot threaten, harass, use another person to communicate a threat or harassing behavior. You cannot be in possession of a weapon or go within 200 feet of where the person works. If you violate this court order, the state can and will file a violation protective order, and you violate those conditions, I can have a hearing to hold you at no bond. Zero bond, and I will do it in a heartbeat to protect every person of Harris County. Do you understand, Mr. Poole? Okay.
So I spoke with pretrial judge, and I spoke with the coordinator. Per pretrial, he's tested positive presumptively, because they have to send it to a lab for confirmatory, for alcohol and THC. I think they described his behavior as
Threatening.
Well, I didn't get threatening, but
I got threatening. Okay. And I'm going to tell you now, I'm not going to have you, and I'm not going to stand for your threatening anyone in this court at any time. That is, every part of this is an extension of us. I don't care where you're going. I don't care what building you're in, whether you're in pretrial services, whether you're taking a drug test. It's unacceptable, and I'm revoking your bond, and he now goes with you.
Yes, sir. No, sir. Arms by your side. All he's doing is setting the rules that you want to follow. Okay.
Yes, sir.
What's the name?
Bledsoe. Evading arrest and terroristic threat. He was in custody because he had a pending felony in the 228. So he's bonded out on all. The evading, I think, is 12 yards per the officer.
So I see that on 10/17 of 24, he picks up a felony assault. And 3 days later, he picks up a terroristic threat. And then he picks up an evading arrest. And they give him PR bonds on these cases? Is that what happened? And
He
here,
bonded out since his last setting. I didn't check to see if they were PRs or not, Judge. I know that he had to pay money in felony court.
yeah, it's just, I'm not down with PR bonds on this. I mean, he picks up 2 new cases if it's the same. Well, hold on a second. Let's not get ahead of ourselves. You've now picked up 2 new cases. You picked up a terroristic threat. You picked up an evading arrest.
I will say our cases are the new cases. So I wouldn't call them
Alright.
new. They're just cases. So he picked up the felony and then afterwards he picked up these 2 misdemeanors.
I don't understand why he's coming here in December when he got a bond in October. How on earth is it?
He was in custody, I think, on the felony.
Oh, I see. Okay, and then he bonded out of the, right, okay.
Yeah.
Got it. All right. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. Please, what happened?
On October 19, 2024, officers were dispatched to a minor crash at a residential home in Harris County, Texas. The call described a male at the location crashing his motor vehicle, then pulling a gun and was trying to fight people at the location. When officers arrived at the location, they observed people at the location pointing at the defendant. Upon contact with the defendant, the officers introduced themselves as Houston police and told them to stop. The defendant then walked into his residence and came back out approximately 2 minutes later. The officers instructed the defendant to come towards them, but the defendant began to evade on foot from the officer the second time. The defendant ran approximately 12 yards from the officer before placing him in handcuffs. A person search on the defendant revealed he had a prior arrest and an active felony warrant. Upon contact with the complainant advised the defendant was driving up and down the street in his car and crashed. The complainant stated the defendant began to tell the complainant he was going to shoot him and kill him. The complainant advised the defendant then began to reach into his waistband and kept saying he was going to shoot him. The complainant feared for his life and felt threatened by the defendant's statement.
I'll say gun was never found. No charges where the gun were ever filed. They charged him with terroristic threat. They would have charged him with ag assault if the police had believed that a firearm was used.
Mr. Bledsoe, let me make something perfectly clear to you. I will do everything in my power to protect my public at all costs. And I don't care if I have to make your bond $2 million. I'm going to do everything in my power to protect my public at all costs. Do you understand?
Yes,
I don't care who you are. I don't care where you come from. I don't care what, nothing. I want my county safe. You will be signing an affidavit with me today, promising me that you're not going to have any weapons whatsoever. And if I find that you have a weapon, I can have a contempt hearing. You're looking at 180 days in jail every time if you're caught with a gun. Do you understand? I'm sending you now for a drug test. I want to know what, if anything, is going to be in your system as well. I'm ordering you not to use alcohol or illegal drugs, and I'm going to test you like crazy. Do you understand?
Yes, sir.
What do you do for a living?
I work for Leland Airmark Bakery.
Okay, that's what you need to concentrate on. Working a lot so that your time is occupied. When you have too much time on your hands, you become self-destructive. Do you understand?
Yes, sir.
Do
You're
you
right about
have? Thank you. Do you have a Texas driver license?
that.
It's a yes or it's a no. Then you're not allowed to drive. On this affidavit, you will also be promising me that you're not going to drive. Do you?
Do you have a different state's driver's license?
City?
He asked if you have a Texas driver's license. Do you have a driver's license from any other state?
No, I'm from Houston.
Okay, sorry. I'm just making sure he didn't have Louisiana or something.
Not drive. I am also putting on this affidavit that you're not going to drive. Do you understand?
Yes, sir.
You're looking around, you're just, heed this warning, Mr. Bledsoe. Do you understand?
Yes, sir. Yes, sir. I totally understand. I only have one off day. I just sleep all day.
Did I hear him say that he had an objection?
No, most definitely not.
He was just
No.
asking me a question.
Okay,
No
just
objections.
don't use. Stay out of trouble. You're in enough hot water as it is. You know, the thing is, Mr. Bledsoe, is that a lot of people make very, very poor choices when they're out there in life. And sometimes that choice makes it to where you will live the next 40 years in a 6x9 box. And I'm going to tell you now, I've read have you been to prison before?
Nope.
I want you to hear me. I've read stuff about what happens in prisons, and it had me in tears. It was as bad as could possibly, if you think of your worst nightmare, it's worse in our Texas prisons. They don't give a rat's behind about you, and you will be passed around like a proverbial doll. It's awful. Believe me, it's not worth it. Don't have a gun.
Yes, sir.
All right?
Thank you, Judge.
All right.
If I can, Judge, I don't believe there has been actually any evidence presented to warrant a
Hold
bond
on, Stephen.
revocation.
She told me yesterday that there had been multiple threats.
So, all right, to circle back, there's a couple things. In speaking with pretrial, I have not received any information about threats. I've received information about cursing and rude behavior.
Yes, Judge,
Don't
there was
speak.
no like threat of like harm or anything like that. It was just more so attitude. He was making people at our office a little bit uncomfortable just with his demeanor and the things that he was saying, but none of it, to my knowledge, has been anything, you know, putting anyone in danger, threatening danger, anything of that sort.
This is where I
You
will.
have an open criminal case. You're to be humble and contrite. And when you're not, and when you're threatening, abusive, harassing, I'm going to take care of you and I will light you up like a damn Christmas tree. Do you understand? It is unacceptable, the behavior that you have displayed here with myself, with pretrial, with the people down over there. And if you don't straighten up and fly right, I'm going to be all over you. Do you understand? One false move again. This is not supposed to be a happy time for you. And I don't know what I need to do to get your attention. But next time, I will classify you as a danger, revoke your bond, and make it so high you will have teeth falling out. Do you understand? Take a seat.
Thank you, Judge. Back to your point. You have a preference on the reset date, Judge?
So tell me what he tested positive for.
It was THC and alcohol, Judge.
Okay.
This is where I will add that the court added bond conditions yesterday, so he had the magistrate.
I understand.
Okay.
He did have
So-
these magistrate orders in October that I did see that he was instructed over. It didn't have no alcohol, but it did have.
October what?
October.
14th, 15th.
Give me the last name again.
Bledsoe, BLED.
Oh, no. He's still smoking weed then. I mean, if they told him not to use any kind of illegal drugs and he tested positive right now, give me the date, please. Come up, Mr. Bledsoe. You're not off the hook yet.
This is where I will repeat my assertion that since he's out on bond, he's entitled to a hearing where the rules of evidence would apply.
What we're doing right now.
Well, then I'm going to object to hearsay to anything and everything being heard by the court.
What day was the magistrate condition for no using, please? October 20th.
I also give my spiel about THC seltzers that I could buy at Specs that have no alcohol but have THC in them.
You are not to use alcohol. You are not to use illegal drugs. I'm going to give you the benefit of the doubt, and I'm going to test you again in 2 weeks from today. If you test positive for THC again, and I don't care what it is, I don't care if it's a gummy, I don't care if it's a joint, I don't care if it's Delta 8, if it's Delta 9, if it's Delta 352, whatever it may be, you will stay with me. Do you understand?
Yes, sir.
Get whatever records you need. But if you test positive for THC again, you're on notice now. You will stay with me.
Yes, sir.
Okay.
Thank you, Judge. Have a seat back in there. Come on. But did you have a preference on the reset date, Judge?
2 weeks, whatever you want.
Oh, I'm sorry, you're right. You said
And
2
I'll
weeks.
test them back and we'll see.
Do you want?